Welcome to Stock Option Counsel. I'm Mary Russell. I'm an attorney and I counsel individuals on their stock options and other equity compensation. One problem with stock options is that there's often a tax bill when you exercise a stock option, and this can cause an individual to have to pay taxes on the exercise of a stock option before they're able to sell the shares. So you think of a startup as being a private company, which means that they have shares that in almost every case cannot be sold because the company hasn't gotten to an acquisition or an initial public offering. Some people address this problem by early exercising a stock option and filing an 83B election. If you early exercise a stock option, early means before it vests. If you early exercise a stock option before the fair market value of the shares increases above the exercise price, then you have no tax bill at the exercise. You file an 83B election, and that applies that tax consequence of zero tax at exercise to all the unvested shares as well. But this is not a solution if you can't afford the exercise price or if the shares have already increased in value and you haven't taken advantage of that opportunity. So the tax code has now added a new section 83I. This is different than 83B. It's a whole new tax code provision that was added in the tax bill that was passed at the end of 2017. And the idea of this was to help with this problem of pre-liquidity tax bills for stock option exercises at startups. So the idea was great. It was meant to allow for people to exercise their stock options and defer the taxes on that exercise until there was liquidity for the shares. That's the idea. Unfortunately, some of the fine print in this tax code provision makes it unlikely to apply to most startup stock options. So keep that in mind, that it's not a grand solution for the problem. But if it does apply to a stock option that you hold, if you file an 83I election at the time of the exercise, it will defer the tax at exercise until the earlier of an IPO or liquidity, 5 years from exercise, the first date the individual becomes an excluded employee, meaning they are over a 1% owner or some other executive role, or that the date that the election is revoked. So some of the requirements that have to be met in order for someone to be eligible to make an 83I election are that the company must have, for this particular stock option grant in question for which they want to make the election, the company in the year that that stock option was granted must have offered options to 80% of their US-based employees in the year of that grant. Also, the individual cannot be a significant owner, having more than 1% of the ownership of the company, or certain executive roles. So you could see why, with the 80% requirement, this is unlikely to apply to most stock option grants at startups, because grants are not likely to be made annually to each individual. So it's unlikely that in any year, except for very early years in a startup's history, that they would meet that 80% requirement for grants. There's also many issues of interpretation that need to be worked out among companies with the help of IRS guidance. So what I'm telling you today is our best understanding of what this provision means and how to think about it. But this is, of course, not tax advice to anyone who's watching a YouTube video. But also keep in mind that there may be changes as we move forward in understanding how this is going to work in practice. For individuals who have stock options in a startup, it would make sense, if you're doing tax planning and thinking about when to exercise the stock option, to ask the company, if I were to exercise this stock option, would I be eligible to make an 83I election to defer tax from exercise until liquidity or 5 years? If you ask that question, you might get the right response, or perhaps your company will still be in the interpretation stages and not ready to answer it. So we're in a sort of strange in-between period now in early 2018, where yes, there's a benefit in the tax code that's supposed to allow for option for deferral of tax at the time of option exercise, but we're still in the interpretation stage, and it's going to be some time, I think, before there's a clear answer for each option, whether the individual would be eligible for 83I election at exercise. Again, I'm Mary Russell. I counsel individuals on their stock options and other equity compensation. I work with people who are evaluating new offers at a company and thinking about, is this the right number of shares and total compensation for the position? Looking into the legal terms of the equity grant to make sure there's no red flags that would limit the value, and thinking about how it might be improved in the negotiation for the legal terms and rights and also the tax structuring. So I'd be happy to hear from you. I'm available at stockoptioncounsel.com. Thank you.